Daniel Efterani here, coming at you with zero Pettifoggery. Sir, I can't even remember what episode number it is. It might be 6, it might be 7. I don't know. I'm going to keep it loose, though. I'm not even worried about it. Friday, June 12th, we're dropping it at you. I got a couple good updates. Marauding for your ears. Starting to think about dropping in a major league grubbing section. As you know, you've been on my Instagram, you know I eat, you know I enjoy some good food, you know I enjoy some good cooking as well. So maybe you'll get an update on that. But for now, you got some updates on the law, a pretty questionable judge. You got some updates for you gym owners. Not some that are going to make you happy, unfortunately. And Marauding for your ears is the podcast CRIMETOWN. I'm telling you, check it out. You better do so. So enjoy. Thanks for stopping in. Tuesday, June 9th, about 2 p.m. And if you are a gym, health club, fitness center owner or in management, you better be paying attention. Recent decision just dropped, and I know this is going to make some of my clients not exactly too happy. The appellate division of the state of New Jersey dropped a decision in the case of Sanchez versus the Fitness Factory in Edgewater, LLC. It is a complete and total 360 from a 27 decision that ruled in the opposite. What that decision is the Retail Installment Sales Act in the state of New Jersey now applies to all health club, fitness center, and gym membership contracts. It's a complete reversal from their previous decision. Previously, the decision that was in Mellon v. Aquacid was in 2017, and essentially the focus of that decision was saying that RISA, the Retail Installment Sales Act, only applies to retail installment sales of goods and services that involve a financing agreement. Now, if you look back at the act itself, reading a lot of legislation is exactly what us attorneys do. And if you look back at the act, NJSA 17:16C-1 goes all the way to 61. There's individual terms that go through this entire act, and it's a little bit more expansive. As a whole, it falls under the Consumer Fraud Act, which is, if you're a business owner, you know that phrase just sends chills down your spine. So this decision puts all your gyms, your memberships, your fitness centers, your boutique personal training, all under the Retail Installment Sales Act, RISA. What that means to you. So whenever you're signing a contract for a good or service that is over $25, there's some necessary things that must be in your contract. One of those things is a 3rd business day rescission term. In addition, every contract needs to include the name, address, the amount paid in cash or the cash value. It must exclude any waiver of rights for the consumer. There must be a total ability to rescind your contract within 3 days. If you were to file suit as a consumer against an owner, this suit will include court costs and attorney's fees being awarded to that buyer if they're successful. There are a lot of provisions that involve the maintenance of your books and records regarding each transaction. There's a requirement to provide the copy of your contract to your consumer as well. You must keep your receipts for up to a year and a half. And there's some stiff penalties to the violation of this. The stiff penalties start with a disorderly persons offense. It's kind of bizarre that that would be the case in this circumstance, but a disorderly persons offense is, in the state of New Jersey, a misdemeanor, and it includes up to a $500 fine. So, big decision, scary decision for some of my clients, but something that I think we're going to get to be adjusting to over time. You're going to see your gyms, your health clubs, your fitness centers offering contracts that include this language, and if they don't, they're setting themselves up for some really dangerous and some very costly litigation. So heads up to you business owners in that respect, and don't hesitate to reach out to me if I can help you and advise you in these circumstances. Talk to you soon. Hey everybody, it's Friday, June 12th, about 5 p.m. coming at you with a quick update. By a unanimous ruling by the State Supreme Court of New Jersey, Judge John F. Russo has been removed from the bench. The controversial decision comes down as of May 26th of 2020. The decision by Supreme Court Justice Stuart Rabner essentially says his overall behavior reflects a lack of probity and fitness to serve as a judge. In light of the respondent's serious and repeated acts of misconduct, we are compelled to direct that the respondent be removed from office. There was some discussion by the disciplinary board whether or not to have him disciplined for 3 months or 6 months. In the end, they've had him completely removed from office. And essentially, some pretty questionable circumstances that I don't think any person should be saying in any circumstances, nevertheless any judge. In April of 2017, he was accused of throwing a file at his law clerk. He had other allegations, including presiding over a domestic violence case in 2016 where he asked an alleged rape victim if she tried to prevent the attack by keeping her legs closed. The judge added in that particular case, "What I lack in handwriting skills, I am the master of, on the record, being able to talk about sex acts with a straight face." Judge Rabner said, especially when it comes to sensitive matters like domestic violence and sexual assault, the tone must be dignified, solemn, and respectful, not demeaning or sophomoric. Just kind of astonishing, some of this behavior. In a paternity suit, Russo held a 9-minute telephone conversation with one of the parties in front of a crowded courtroom. When that person refused to divulge her personal home address on the record, saying she feared for her safety of herself and her child, Russo threatened to fine her and told her, "He's going to fine you," speaking about the father, and said, "We're all going to find you." Rabner said that Russo's disturbing comments and questions were insensitive, threatening, and discourteous, and they reflected poorly on his temperament. I could go further on into this story, but it's simply on conduct unbecoming of a judge, not something you would expect walking into a courtroom, and not something that I would ever want anybody to even hear as a normal citizen. Kind of outrageous stuff. So that's your latest update. Judge John F. Russo removed from the Supreme Court bench. Hey everybody, about 10 o'clock Monday. As you can see, you're going to start to realize that I'm wearing very familiar shirts on a regular basis. Probably because I have only a selection of long sleeve t-shirts. It's not really acceptable to not have a long sleeve t-shirt while I'm blasting the air conditioning. Welcome to New Jersey, I guess. Well, this week, Marauding for Your Ears is a favorite podcast, although I'm eagerly awaiting season 3, is CRIMETOWN. The first season focused on Providence, Rhode Island, and a mayor by the name of Buddy Cianci. And the second season focuses on good old Detroit, Michigan. It discusses organized crime. It discusses politics. It discusses so many different issues. And it's just historically astonishing in some ways. And they do a really good job of storytelling. So check it out. Thanks. Hey everybody, settling in for a Friday night of some work in preparation to celebrate my godson and nephew's first birthday tomorrow. Jack, love you buddy, can't wait to see you tomorrow. Quick update, State Superior Court came down with a ruling in the matter of State v. Colson. Defendant was essentially arguing that because he was licensed in Pennsylvania, being an out-of-state driver, that he was excluded from any order to install the interlock ignition device in accordance with the new DWI or DUI sentencing guidelines that I spoke about previously. He was essentially arguing that the intent of the legislature was to exclude out-of-state drivers and essentially not require him to install the interlock, partially because I'm certain that it would be quite difficult for him to have it installed as well as maintained within the state of New Jersey, unless he could find somebody in the state of Pennsylvania in the meantime, while he was required to install it. So interlock is being required for even out-of-state drivers. In this circumstance, he refused to take the breath test, which is a very, very questionable decision. Doesn't leave your lawyer with a lot of outs, I'll tell you that. So like always, as I always say, if you're going to enjoy yourself and indulge in adult beverages, first and foremost, do not drink and drive. Be very responsible, and I hope everybody has a great weekend.
Put your hand down. Why are you smiling? Cause I love the law. The law is fun. Fun, sir. It's fun? Yes. You sure? I think. Now you're thinking. First you smile, then you're thinking. You think the law is still fun? Yes. Sir. Yes. No, sir. No. It was fun. Not anymore though, is it? Is it? Not right now. It's not fun anymore? Not even a little bit. No. Make up your mind. Think, since you're thinking. Go on, think. Is it fun? No, sir. No? Absolutely not? 0 pettifoggery, sir. All right, listen up. I'm Daniel F. Deraney, and I'm going to tell you how much fun you're going to have this episode.